Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Welcome to the show. Today, we're talking about the top mistakes real estate investors make in their contracts. I'm Andy Feller, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. You can find us on two primary channels, on YouTube and on Facebook. YouTube is the preferred venue. Go to YouTube. You can find us at INREM Podcast. That's at INREM Podcast. Make sure to subscribe and give us a like. With that, we're going to go to Sean, who's going to give us our legal update for today.
Thank you, Andy. So today what I want to talk about is the nature or the structure of a subject to transaction. There are a number of ways that you can structure a subject to transaction. The traditional method is to take title by warranty deed via a purchase contract. And then when you take title, obviously you're taking it subject to the existing loans on the property. When you take title and use this method, how you structure it is important. In my opinion, a subject to transaction should be structured with providing the seller with some form of security for as the buyer's payment of the existing loans. So what I mean by that is you're going to deliver to the seller a promissory note that basically states, I am going to perform by paying the existing loan. So it's a performance note or a performance promissory note. I'm going to perform and I am going to pay the existing loans. And if I don't pay the existing loans, then you have a right to foreclose. And the way you would have the right to foreclose is I will give you if you're in a deed of trust state, I will give you a deed of trust. So here in Arizona, we use deeds of trust to secure obligations. So I'm going to give you a deed of trust. And if you don't pay, if I, the buyer, don't pay, then you, seller, can foreclose under the laws of Arizona utilizing that deed of trust. Or outside of Arizona, it would be in states that use mortgages and not deeds of trust, it would be a mortgage. So if I fail to pay those existing loans as agreed, then you have the ability to come in and foreclose using the mortgage. So according to the laws of the state, I go through the foreclosure process and I foreclose on that mortgage. This is what we call, and has been traditionally called, a wrap transaction, where you basically take a promissory note and a security instrument such as a deed of trust or a mortgage, and you wrap the existing financing. So it's wraparound. You basically wrap it with a note and deed of trust given to the seller that secures the buyer's performance of paying the existing loans. The reason why I like a wrap transaction as opposed to basically entering into a purchase contract, taking the property with a warranty deed and just taking it and saying, well, I'll pay the loans or agreeing in the purchase contract to pay the loans, but not giving the seller any form of loan instrument or security instrument, is a couple of reasons. One, I like it better because wraps have been around for forever. And in the legal realm, most real estate attorneys are going to know what a wrap agreement is or a wrap transaction is. And it's so if you ever are, if the transaction is ever challenged in court, you could go into court and say, Judge, this is a wrap. This was a wrap transaction. And most judges say, oh, okay, I understand what a wrap is, versus this is a subject to, I receive a warranty deed, but then I didn't give the seller any security. A judge may look at that and say, well, wait a minute, how's the seller protected in this transaction? and call into question the nature of the transaction. You still might prevail as the buyer, but having it as a wrap transaction gives it an air of legitimacy because wraps have been around for so long, and most real estate attorneys are familiar with them, have prepared them, and are used to working with wrap transactions. The terms subject to, sub to, that's kind of a newer thing, and so some of the older attorneys, even judges, may not be familiar with those terms and those transactions, and would require extra education. Second, is by giving the seller a promissory note, you're giving the seller basically an asset that it can use potentially to show to a future lender that shows, hey, look, I'm receiving these monthly payments under this note. And that should offset some of the debt to income issues that they might have on obtaining additional financing. It also provides a certain level of protection in the event of, what happens if the seller, passes away or files for bankruptcy or things like that. You then have a document that exists that basically is an asset, even though it basically mirrors the existing loan. It's still something that can be assigned. You can assign the promissory note and the obligations under the promissory note to, say, a bankruptcy trustee or to, heirs of an estate, versus if all you do is have an obligation in a purchase contract and then you take title by warranty deed without giving the seller any, form of traditional security. You don't have that ability in those instances. So in my view, when you do a subject to transaction and you're going to perform that transaction by a purchase contract followed by a warranty deed whereby the buyer takes title, you should wrap that transaction or wrap the existing loans also using a note and some form of security instrument like a deed of trust or mortgage.
All right, Sean, thank you for that legal update. So today, as we get into kind of the substance of the show, we want to remind everybody that we are taking questions and we're taking live questions, but you don't have to wait till the end of the show to ask a question. You can leave a comment in the section, and I'm going to turn it over to Mayu to kind of explain what we're doing, but we want you to participate and have the option to ask Sean or I questions or our guest questions as well. Mayu, why don't you tell them what they need to do?
Yeah, so if you guys are watching from any of our YouTube or our Facebook Live, you can drop your comment in the chat, and then in the last 15 minutes of the show, we will go over those questions. So back to you.
All right, so today we're talking about strategies for dealing with the top mistakes real estate investors make. And there are a lot of them, more than you could probably possibly cover in one show. But today, discussing that with us, we have Ohio attorney Paul Vincent. Paul is with Vincent Esquire, a law firm in Ohio. Paul, thanks so much for joining us today.
Yeah, guys, thanks a lot for having me on again. I must have guessed well enough last time I was on, and I appreciate you having me on. Hopefully provide a little value for all your listeners, and they can learn a thing or two.
Oh yeah, your polling was off the charts.
That's right.
No, we appreciate
three
you.
three lawyers in one podcast. I mean, wow.
Yeah, we're hitting all the buttons.
That's right.
Yeah, we appreciate you being with us. So, and we know you've been with us, but we've got some listeners that maybe aren't familiar with you. You were on a show with us the last time talking a lot about securities law, and we'll talk about, I'm sure, that some more today. But why don't you tell us about your practice, your law firm, and how you got involved in real estate investing or representing real estate investors?
Yeah, sure. So when I started my firm with my brother Adam back in 2016, we had a huge client that bought tax lien certificates. So we helped execute on all those. And that was something I didn't know anything about until this lawyer friend of mine who was helping them in Southern Ohio was like, hey, they have a big, several hundred certificates up in Northern Ohio where you are. Would you like to help us? Well, Adam and I chewed it over for about 20 minutes and naively opened up our law firm about the next week and learned a ton about tax liens and tax lien certificates and how foreclosures worked for that and how you worked with consumers and all sorts of stuff. So, during that kind of hasty time, we discovered that real estate is a vehicle that you can do a lot with. Obviously, tax lien certificates, like I said, I knew nothing about them until we opened up our shop and we started helping our client with them. And then from there, we went to non-performing paper. We learned a lot about that. We helped clients with dealing with that, which is just, secured paper, traded, usually in default, sold at a discount to another buyer, and found out a lot about that. And then we found out about all these like more traditional investing vehicles like house flipping that we only saw on TV, and then multifamily. And when we found out a lot about multifamily from some local guys nearby, we started finding out about securities work and helping people close deals and educating people about how to do it, what we think well. And with that, they need you at the front end and at the back end, a lot of those deals. So, we started doing a ton more real estate PSAs. So
Good stuff. So we're talking about mistakes made in real estate contracts. And
yeah,
I think it's important on the front end to just note and kind of talk who we're dealing with, which are investors, entrepreneurs who are out to make money. And oftentimes time is money. And my suspicion is a lot of the times the rush to the deal is maybe the reason for a lot of these mistakes, or just kind of the sheer awesomeness of what the internet provides. So much information, you think you can just go get a quick form and you can just do just about anything no matter where you are, and then details get left behind. So a lot of these mistakes, I think, are probably the result of people rushing through deals. But we want to go through those and identify ones that we've seen in different categories, and at least help investors better prepare for how they can protect themselves and the fallout that potentially play out on that. So the first category we wanted to kind of talk about and see what you've seen in this is, I think, a common one, but leaving important terms blank on a contract. This could be a form contract. Maybe it's not even a form contract. Maybe it's their own pre-prepared contract their own lawyer did, and they just, of course, they had blanks put in the form so that they could use this from deal to deal, but just failing to put
yeah.
important terms in the contract. What have you seen in that? What kind of fallout have you seen can be the result of that?
Yeah, and this goes back to your initial point about speed. A lot of sellers want to sell their property yesterday, right? And every buyer, especially new ones or folks that haven't had a deal fall through poorly, they want to accommodate, right? They're like, hey, I finally got this person on the phone for this single family deal or maybe apartment or something like that. They just want to close the deal. Maybe they've gone to a Hype Fest weekend event. Now they just want to crush and rocket ship their way to being a millionaire. So they end up speeding through the PSA. So kind of initially, I'd like to say, make sure you have a lawyer helping you. Even if you have a lawyer that's put a template together for you once, send it to somebody to once over it, because going back to the point about leaving things blank, nothing should be blank, right? I mean, why leave anything up for discussion either at the end, right before it's going to close, or when it goes poorly and the deal gets dropped? So some of the most obvious ones are, I talk a lot to clients about protecting value. So you want to make sure there's language in there that you can protect your value, either through an assignment, right, to somebody else, or an assignment to yourself. If it's a big enough deal, the ultimate lender is going to want you to have a single purpose entity. And with a single purpose entity, Paul Vincent might have it under contract, but I need to make this new LLC typically that's going to be the title owner. And if you're a seller that's been kind of maybe burnt from some internet wholesaler clowns that don't actually close the deal, you're going to be very skeptical of who the actual buyer is. So if you have it in your contract, it's called ASAOA. It's successors and or assigns. That's a very common commercial term, ISAOA. If you say Paul Vincent, ISAOA, it's successors and or assigns, that will at least bring up to a seller that there's going to be someone else that's ultimately on title. And if they don't know what the hell that acronym is, they'll ask you. And you can be like, look, I do it this way because this property is $1 million+. The bank's going to want this separate LLC to be the owner that's free and clear of any other, asset. So that's the first thing, is not having a term in there, because at the beginning, if you've been building a relationship over a period of time, of course you're all going to be friends, right? You're like, I'm a buyer. I'm going to pay what you think, probably an overpriced, value on your assets, so we're friends. But when it comes down to it, and God forbid when the lawyers get involved, and there's gets to be a little adversarial process involved, then those missing things are going to be important. So that's like the first most obvious one to me. The other ones are like deadlines and timelines, but we can talk about that later.
Yeah, and what I notice, and just curious on your thoughts on drafting style, is I've discovered that the more blanks that are in the middle of the substantive terms of the contract,
Sure.
the worse it is
Yeah,
for
right.
these investors. I see over and over where I receive forms that require you to work paragraph by paragraph and fill in blanks. And to me, it just they miss it. They miss critical things like close of escrow dates and
Sure.
deadlines to deposit earnest money and things like that that have to be filled in the middle of the contract, and they just get lazy and overlook it. What are your thoughts on how to draft a contract to maybe avoid that type of thing from happening?
Yeah, one of the problems I think with drafting contracts too is the point in time between the parties either having an LOI or coming to some terms with a seller, like buyers and sellers come together, and then when they send off their deal to the lawyer, if they do that, hopefully, I mean that's number one. Make sure you have a lawyer do it. Let's say they do send it to a lawyer. There's always some period of time where it's like the deal's hot, everyone's excited. But then if the lawyer's busy and ends up being 10 days for the lawyer really to put it together, there's so much translation that's lost during that period of time, right? Even the buyers and sellers aren't really even sure what they agreed to, right? And then, that's where I see a lot of problems is just not enough communication with the actual client other than the LOI. Because there's always stuff different. If you've never used this lawyer or their PSA before, their purchase agreement is going to be much different than the simple LOI you probably sent over to a seller. So you need to have more communication. I think that's, you got to get on the phone. Unfortunately, like I'm not a phone guy. I hate getting on the phone, but I got to get on the phone for all these deals. And yeah, so I think that solves a lot of problems because then you can go through it. Even if you're like, hey, I'm going to do a draft of this and we're going to have some stuff that we need to talk about, then you have that call and you can cut out a lot of the discussion, but at least you can get to the blanks to make sure there's no blanks when you fire it over to a seller.
Now, the concern obviously with, waiting on an attorney for 10 days is another investor, at least this happens in Arizona, comes in and
for sure
slides in and ends up, having the seller sign a contract, even if it's not a well-drafted contract, but gets it under contract before the, original investor. Because honestly, these investors, at least here in Arizona, have kind of the same formula of who they're reaching out to and why they're reaching out to them. So a lot of times, sellers are being contacted by multiple investors. How does somebody avoid that 10-day period from, ruining the deal? Because I'm with you. I mean, something comes to me and, it's very rare that I could turn something around in 24 hours with my, schedule and workload. But what can maybe be done in the meantime to lock in that property?
Yeah. I mean, a binding LOI, right? That people can put together themselves with some real value that you're handing over. So if it's a deal you really want, you should be able to put up some non-refundable $250, $500, $1,000, right? And if you're not able to do that, because if you're in a market like yours, that if it's not taken down within the 24 hours of the agreement, then you need to come up with something. So that would be my suggestion. Say, hey, look, this is going to be binding, but I am going to give you a non-refundable chunk of money, showing you how serious I am. And that cash solves all problems. To a lot of sellers, if you were to give them $500 cash to buy it at the agreed to price, you're not going to get a lot of people to object to that, because that's a lot of money, especially to someone, in a lot of these deals, they have some sort of pain point. So $500 can go a long way. So if I were someone in a really, really, really hot market where someone can take your deal underneath you in a week, then come up with some dollar amount that you can hand over. And maybe it doesn't have to be $500, right? Because not everybody's got that. You say, hey, I'll give you $50 if you give me a week. That might work too. But you got to give them something.
Right. So it's kind of like an LOI that basically says, hey, you're going to only negotiate with me.
Right.
And yeah, interesting.
That happens a lot on the commercial side. I don't think many people do it on the single side, but if you're in a competitive market, you got to come up with something where you're not doing your own PSAs only because successful lawyers take a little time to send stuff, right? If they're able to turn something to you in an hour, that's awesome. They either have the systems in place and they're at a really efficient shop, or they just don't have a lot going on and they hope you call. So
right. We had an attorney on, Bree Riles from Illinois. She's licensed in Illinois and practices real estate law up there. They have an interesting thing in their standard form contract. So it's not the law of Illinois. It's just in the realtor form contract that basically is like a 5-day period in which the parties, they sign a binding contract, but then the parties can go to an attorney, and then that attorney can send back recommended, changes and revisions to the contract, almost like a buyer's inspection notice, where the buyer, like the seller, for example, could come back and say, no, I'm not going to do that. And then the buyer has to decide, do I cancel or do I go forward? You know what I mean? Type of thing. So it allows the attorney to clean up maybe some, problems in the contract within that 5 days. But at the end of the day, both parties are bound by the contract, but then can, exit, like a buyer can exit during an inspection period or that type of thing. So,
yeah, that's, I don't disagree that that's like a terrible thing. Because what I think happens, a lot of people that aren't sophisticated, right? This might be their only transaction they ever do outside of when they bought the thing. It may not seem that unusual to you if you're a seller to get 90 days due diligence or something like that, right? And that's just a way for a wholesaler to just buy find an end buyer and have no like obligation to the deal. Right. So that's interesting. I've never heard of that, but sounds good to me. If I'm a seller, for sure. And if I'm a buyer, it's like, I don't want the buyer's remorse to happen after it closes and then I get sued, right? Then there's no deal that's worth getting sued after the fact if you just would have got it out of the way early. So.
Right, exactly.
Paul, one of the selling points of the transactional attorney is that we can craft quality language that is clear and concise, and any reader can understand and know what was meant by this. Sounds easy to do, not all that easy to do, but one common mistake we see in all contracts, and it's what litigating contract attorneys make living on, is vague and ambiguous language. And there's even more of a risk, I think, of vague and ambiguous language when you're trying to rush a deal or you're waiting for the lawyers to finalize things. What have you seen? What kind of mistakes have you seen with regard to vague contracts, and what are steps investors can take to ensure not to make those mistakes?
Probably one that stands out that I see a lot of is finance contingencies. It's like we make good faith effort to go find a company to finance this deal. What does that mean, right? Like, and how do you disqualify the deal from a financing contingency? So that's one, because it's like, hey, I got a broker lender that's willing to write me a letter to be like, yeah, this deal stinks, I can't lend on it, so that kind of ambiguous situation I could see being a problem. I've never had a deal where anyone actually sues for that kind of good faith effort, but that's one that's squishy, right? It's kind of like, well, what does that even mean? How do you qualify for that sort of thing? And that's never well defined. It's just like, hey, give me some time. And that's usually to the buyer's benefit, right? Because if it's a bad enough deal, like a lot of these value add deals are, a lot of banks are like, hey, the occupancy is too low, or it's I've had deals go sideways like a week before closing because there was a like a gunfight, at the apartment complex and that sort of thing. That's never defined, right? But that obviously changes the contingency. Now, does that mean, that we should be able to get out of the deal because no longer get a bank? Well, no, there's got to be a bank somewhere. So that's a big one I've seen be a problem.
Well, one of the ones that I've seen that creates issues is dealing with the timing of close of escrow when there's like title issues. Sure. And I've even seen it in form contracts that investors are using where it basically says, escrow shall be automatically extended if seller can't clear title. And it's like, okay, a couple of things. For how long? Right. It doesn't say for how long. And then second, what does clear title mean? Meaning,
Sure.
you and the three of us know you never take clear title. You always take it with, CC&Rs or maybe a utility easement or
Sure. There's
something like that.
easements galore. Right.
Yeah,
Yeah.
that you're willing to accept, and it's fine. You'll go forward. So, what does clear title even mean when they put that in there, right? And so, it's those types of things that I think create issues, because then the seller could come back and say, "Well, I have cleared title," and the buyer's like, "Well, I
Yeah.
don't want that
I mean,
easement or this or that," and it's like, no, everybody's going to buy it with that utility easement, type of thing. So,
yeah, it's really, they mean clear to close. The bank's happy enough to give me the money.
correct.
It's not,
Yes.
nobody cares. They're just like, what can I do? What do I get to close? And it brings up an interesting point. I've said a few times on the internet lately, is just because a bank's willing to lend you money on a deal doesn't mean it's a good deal. Banks are in the business of making money too. So, they're willing to kind of roll the dice maybe on a few deals, but just because it scratches a bank's underwriting and they're willing to fund the deal, doesn't mean you're ever going to make any money on it. Doesn't mean that you're going to be able to support the debt, right? It's all
Right.
subjective on kind of what a good deal is. So just as kind of a side, I would like stress that to everybody. Just because a bank's willing to give you some dough doesn't mean it's one that you should be spending a ton of time on.
The other one I run into, I don't know if it's just me. I don't hear a lot of people say this, but I seem to run into this all the time. But investors or clients who aren't just careful enough about the terminology that they're using, so they confuse things. I get this all the time. They confuse loans that they're making as part of the deal with what probably is a capital contribution or something like that, and they'll call it a loan when it's really a return of capital, or vice versa. And as you get into the deal, you're like, well, this sounds like a loan, but you're not calling it a loan, or this sounds like capital, but you're not calling it capital. This doesn't have any interest rate to it, but you're calling it a loan. And I see that issue all the time, and I think that's just I think it's just lazy. I don't want to say lazy, but just working
It is.
quick
It's fine.
to
Yeah.
come up
No,
with
it's
the deal.
yeah, and a lot of the problems come to one of the sides not being educated about something, right? So like if you're a seller and you just want, you have this gnarly, hairy, at least what you think, big problem. I mean, I've seen people get rid of deals or file bankruptcy on things that are very minor because they don't have the perspective of what's on the other side. They don't have anybody to ask, right? They're just like, hey, somebody called, I'm under stress. I just want to get rid of this stressor in my life. Then they're willing to give away basically the farm. And then at that point, like you said, people are doing these 0 interest loans, whatever they're called. And then they're hopefully going to, realize it back in their bank account at some point in the future. But yeah, there's also, the benefit of the internet is that people can learn all sorts of things. The downside of the internet is that people can come up with all sorts of creative things. You post about it and it's like, oh, it's, I saw it on YouTube. I should be able to do that too. And yeah, you could get away with a lot of things. It just it doesn't, one, mean that you should, or two, doesn't mean that it's going to catch up to you later.
So speaking of lazy contracting and being in an internet age, let's talk about just straight up using the wrong form for the wrong deal. It is so easy to go online and find a PSA that somebody did in some deal.
Yeah.
Damned whatever state this might come from. We're not even going to look at that. We're just going to use the form and we're going to do it.
Yeah.
Do you see that in your practice?
Yeah, I see it. I don't really do many residential things, but I do have like a little like course and group and stuff like that. And what I see a lot of people doing are a lot of these they call them lease option contracts or what's the word? Rent to own. Rent to own stuff.
Mm-hmm.
And I see that all the time. And actually for demonstration purposes, we actually pulled one off the internet that had it wrong. They had this lease option where you were paying principal down over the life of the thing. And I don't know if Arizona has land installment contracts or contract for deed, whatever you guys call it out that way. But I see that all the time. People, and it's, I think everyone's intentions are good, right? They're like, hey, you're paying me a chunk of money up front. You pay me every month. I'm going to actually pay down the principal. You're probably not a person right now that would qualify for a traditional loan, so I'm going to be your bank. but it's a problem. And we see that a lot where people are paying down principal, I think with good intentions, but now that the seller's paid for more than 20 or 30 or 50% of the principal, they have different legal rights than they do as just a regular old tenant, right?
Right.
And they're under Landlord Tenant Act in every state on one of those lease options, which is much different than under the land contract law in every state. If they're, every state has it. So that's a big problem.
Right. And Andy and I, or at least Andy still practices a little litigation, but I practiced for 15 years. And to your point, what would happen in that case is, and I think what you're getting at is, you can do a lease option, but the lease should never reference the option, nor should any payments under the lease be used to satisfy the purchase of the property. There should be a separate option fee paid for the option. Now, the option can reference the lease as being a lease in performance, and if you breach the lease, the option is terminated. But the lease should never reference the option, because in Arizona, and I'm sure the law is the same in Ohio, is there's no statutory procedure to deal with somebody taking some type of, ownership interest in the property via a lease. They take a possessory interest, but not an ownership interest. So what happens is you go into justice court and you're looking for your quick, 5-day eviction, and the justice of the peace, at least here in Arizona, all you need is a high school diploma. And you can be elected as a justice of the peace, making these legal decisions.
That sounds way cool. A lawyer. I would just go to Arizona to be that.
It's cool. Yeah, it's cool until you're a lawyer in front of them. But
we'd vote for you, Paul.
We might have
right.
Yeah,
that's good.
But in any event, no. Most of them, with that said, most of them do a pretty good job. But what will happen is you'll go in front of this, justice of the peace, and you'll present your the lease and be like, Judge, they haven't paid their lease, evict them. And the justice of the peace will see in the lease, oh, well, wait a minute, part of the rent payment went to pay on this option. And they'll go, oh, that's an interest in real property outside of eviction. Go to Superior Court. I don't have to deal with this. And then you have to go to Superior Court and do some form of quiet title action. And there goes your 5-day, eviction. Now you're stuck in a quiet title action that's going to last, a year and a half,
Right.
Yeah. I mean, so in any event, that is a major problem if not drafted right. Versus, like you said, the simple solution is, if you're going to do that, you can still give a possessory right with a contract for deed or an agreement for sale. But here in Arizona, we have very clear statutory procedures for the forfeiture of that interest.
For sure.
But you just don't have that in a lease if the lease has, those types of provisions. So it's a major problem. I've seen that a lot. Good point.
Yeah. I mean, just ask a lawyer, it's not a big deal. You spend $300 asking a lawyer if this is how you're supposed to do it. And they'll, take your money and they'll tell you yes or no, and they'll hopefully be able to direct in the right direction. But if you want to do someone a solid, then actually give them equitable title when they're making those monthly payments. So just do it right. It's not complicated stuff. And exactly. if I'm the seller, I want the contract for deed, because then I can really hand over all the responsibility of the property, right? I'm outside of the Landlord Tenant Act, where I'm obligated to make everything habitable, and arguments about, all that stuff. It's not my responsibility at that point when it's a contract for deed. So.
Yeah, exactly.
Well, another area where we're it's really easy to just go get a form on the internet, but extremely problematic. And Sean preaches on this a lot. And Sean, maybe you want to speak to this, but it's the assignment form, because here in residential real estate investing, where there's wholesaling and things like that going on, the assignment's really important. And you can effectively sign something in 2 sentences, right? I assign all right, title, and interest to the following whatever, to the following people, and bam, you've got an assignment. But as we found in a lot of the wholesaling deals or deals that we see here, a well-crafted assignment dealing with a number of contingencies is really important, and just a paragraph on the internet is not going to cut it.
Yep. No, it's the internet is helpful, like I said, but it can be harmful, probably just as often.
So let's talk about, subject to transactions. They're pretty hot here, and they're pretty hot in a lot of states. But one mistake that we see is just not having all of the documents that you need to for the transaction. And mainly in a subject to transaction, we're really talking about disclosures, all the necessary disclosures to disclose that there are liens and all kind of the background of the property. What have you seen there?
Yep, that's it. So a lot of problems occur in wholesaling and sub two and any of these kind of creative financing things is that people are uncomfortable, right? They don't want the question to be like, well, why would I sell it to you subject to where I got to keep the debt, and how's this all going to work? And what I kind of imagine problems being and problems that I've heard of anecdotally is that since the question was never asked, I never really brought it up, So I think disclosing is everything. Bolding everything is so important. Making sure people have a period of time to find their own counsel. And yeah, maybe the deal goes south because they have. That's way better than the decedent's son or daughter finding out what you did to their sweet old mother on that property and coming after you with a lawyer, with maybe, the state's attorney general or, something like that. You just got to be like overly cautious and upfront with your disclosures and making sure everybody's on the same page, because that is way better losing the deal that way than having somebody find out about it and being really pissed off later.
Well, and to your point, more and more states are starting to enact legislation that deals with disclosures that have to be made when you have an investor, for example, a wholesaler, or somebody purchasing the property subject to the existing financing. Here in Arizona, we have certain disclosures that can be made, that have to be made regarding assignments and the intent to assign. And if you try to assign it without having those disclosures in that contract, it's no good. The seller can back out and keep your earnest money. But and of a more serious nature are states like Colorado that have what are called foreclosure rescue laws, which basically state that if a loan is in default, which is 30 days past due, so it doesn't even have to be a foreclosure scenario.
Sure.
But basically, if a loan's in default and you're going to go in and buy the property subject to, you have to give a lot of disclosures, and then you have to have some magic language in the contract, to your point, saying you have 3 days to rescind, and not only that, but you have to then disclose. And during these 3 days, we recommend that you go see an attorney or seek the advice of a housing counselor. And at least in Colorado, here's the number. And you have to actually put the number,
Really?
the statutory required number in the purchase contract. Well, there's serious consequences if you violate those statutes in Colorado with the AG, like you were pointing out, with the AG there. So, that's the other thing, is just grabbing a form and thinking it can be used in any state without researching the specific laws of that state and seeing what are the specific disclosure laws that I have to comply with here in this state in order for this contract to be enforceable.
Serious business, but if you're gonna flash your fancy car, you got to deal with the consequences, so
That's exactly right. Yeah.
I'll say, like, what other industry does that? Is there one? Is there biomedical sales or doctor? Like, no one does that. Why real estate? Why does everyone do that? I don't know.
Back in the day, that's how attorneys were, right? I mean,
where are those glory days? Now it's like, I went out to lunch,
well, yeah, exactly. When I was growing up as a young associate at a firm, most of the partners were driving some pretty sweet rides.
Cool. Glory days.
Yeah, the glory days.
What about failing to appreciate the additional signatures and documents that are going to have to be signed following the purchase and sale agreement? Never before did I really run into the need for, let's say, like the cooperation clause in a purchase and sale agreement until some of these subject to deals or some of these other real estate deals where there's a lot of cooperation needed on some of those. But even little clauses like that, or the need to get powers of attorney, do you see deals fall apart or fail because of just lack of back end work that needs to get done?
Yeah, but a lot of times I see it. It's usually like the left hand doesn't know what the right hand's doing, right? Like I'm dealing with one now where there was a pretty significant chunk of this complex that had some housing authority checks that were supposed to come. Well, it's been like 8 weeks, right? And like on our side, it's kind of like, well, how did you not know for this period of time that you didn't get these checks, right? But then on the other side, the seller who just kept housing them, I don't know what they did with them, if they deposited and used them in their operating account or what they did with them. But it was discovered about 8 weeks after the deal closed. And it's like, how did you not know that? So um, you got the biggest, I think, most important thing is, and this is more on the commercial side, is if you have lawyers that can work together, like buyer and seller lawyers that work together, these things all generally wash out. They may take longer than the parties want, but you don't have to go to litigation. On the single family side, it's just a lot harder, right? Because a lot of people under distress situations want to leave that part of their life behind. So getting them to come back to earth and sign something for you, you're going to have a really hard time. So you might be going back to quiet title, on something if there wasn't something executed properly. But yeah, it's something you got to be real careful with, and something you hopefully take care of at the closing table. But every deal has its own problems, I guess.
Let's talk about another area where I don't think nobody on the front end of the deal is thinking about the back end of the deal or what would happen if this deal goes south. So really thinking through the kind of remedies that you would need. Now, Sean, in his legal update, really spoke to this with regard to a subject to, looks, you ought to think about doing a wrap so that you don't just have some sort of contract right to pursue this, so that you can actually foreclose if this buyer is not paying you on this subject to deal and get your property back. So thinking through the appropriate remedies that you're going to need. Have you seen this mistake? Is that common?
Yeah, not that often. I mean, I don't, I've put out on the street that I have no interest. I only deal in happy transactions. So like, I don't really get the back end stuff. Please lose my number if it goes sideways, sort of thing. So anecdotally, I don't have anything that really stands out as far as non-performance. Some of the stuff, one of the things I'd like to mention for anybody listening that's either getting into it or now going to scale up into bigger properties, on the subject to stuff, it's a lot different to take something subject to, that's a $150,000 house that you're going to turn into either a rental or some Airbnb play. But then you're like, hey, I want to go to buy this mansion now, where there's real risk if you don't fill that. So one of the things I want to mention to people on both the commercial and residential side is don't buy above your weight class unless you have a tag team partner that can get you over the edge, because so much of real estate is this mindset stuff. It's like, okay, I believe in some of it, but a lot of it too is like just naive. So if you're taking on $1 million mansion or you're buying an $18 million apartment complex, don't get yourself hyped up and buy outside of your weight class and then deal with maybe a lifelong problem with it. Someone else's EMD money, a seller with the dollars to sue you for the breach, coming after you for some significant amount of money because you said you came in, swooped in after the big conference, and you offered 18 million when somebody else only offered 16, and now you're getting sued for $2 million. Don't buy above your weight class because it will cause you a lot of trouble.
Well, and to your point, here in Arizona, there's a reported or a published decision way back before even 2008, but it was during a downturn in the market where a buyer, it was residential, but a buyer goes in, makes an offer to purchase, and the agent was aware that the buyer had some credit issues and did not disclose that. Well, this property was there was equity in the property, but the seller was cash poor. They could not afford to pay the payments, and so it was a distressed property. It was going to go to foreclosure, and the buyer didn't disclose their inability to close on the transaction, and then of course the last minute the buyer pulls out and the seller then turns around and sues the buyer and the buyer's agent, saying you should have disclosed to us your inability to be able to purchase, because what happened was the seller lost the property in foreclosure and lost a chunk of equity. And so they went back and said, hey, had I sold it fair market value, I would have received X amount in my pocket.
Yeah.
Because it's stressed, I only received Y. I'm entitled to the difference. And the court said, yeah, you can sue both the buyer and the buyer's agent for not disclosing the buyer's inability to, purchase the property. So it's a major issue to play within your weight class and only take on transactions that you're, fairly confident you can close.
Yeah, I mean, and one thing for everybody to, if you've never gotten into a deal, or maybe you're starting to get into more deals, like it's serious business, right? It's like people's livelihoods here, people's futures, are relying on these sort of transactions. So you should take them seriously and not go after things just because you're feeling hyped up from the online $97 online course, so.
Right. Exactly.
Talking about remedies, we see this mistake a lot here in Arizona. I'm curious to see whether they have something similar in Ohio. But in Arizona, we have a fee shifting statute for matters that are arising out of contract. So if there's a dispute arising out of contract, the prevailing party is entitled to their reasonable attorney's fees. So obviously, if there's a dispute, there could be an issue as to an award of attorney's fees, which could be pretty important because litigation is costly. That statute treats the situation differently if you've actively put in a provision awarding attorney's fees. And in fact, it changes the award of fees from being discretionary essentially to they will award fees. And nobody ever thinks about that. It's the most important thing to the client when they go to sue. Oh, great, I can get my attorney's fees. But nobody seems to think about that on the front end. They either were lucky because their form contract had an attorney's fees clause,
Right.
or they weren't. They're relying on the statute, and that's the best that they can do. Does Ohio have fee shifting or allow?
I don't know of a statute covering that, but every commercial deal we have where it's like the prevailing party, gets everything paid for, fees and costs and lawyers and all the other stuff. So every commercial deal, residential, like our state contract, I doubt it. It probably has a liquidated damage of the EMD or something like that. But yeah, it's mostly every commercial deal has prevailing party wins the day. And, that's great and all, but it's still like, but you still got to pay me up front. Yeah, we can collect it later, at the jury or when we settle this thing, but you're still going to pay me. So, I mean, a lot of the economics of litigation is what has kept many bad real estate investors out of court because, even if it's, up to maybe $10,000 probably is what most people would be like, well, it's not worth my time because I'm going to spend more than that to get a lawyer. So yeah, it's problematic, but it probably helps more investors than it does sellers because, it's just like, well, I got screwed, but I don't have the money to cover my mortgage. I'm not going to sue anybody either, so.
Right. And to your point, I mean, most attorney drafted contracts are going to have that attorney's fees provision. So hopefully, most commercial
selfish lawyers want to get paid.
Yeah, exactly. But it's the form contracts that we've seen used that, weren't drafted by attorneys or were pieced together and, offered online or through some course, like you said. And the problem in Arizona with our statute is the statute is discretionary, but most judges will award them, but it only applies to a contested action. And a contested action means one where an answer is filed. So let's say that you're an investor and you're like, oh, wait a minute. This seller's not wanting to sell. I've done everything right. I'm going to do a specific performance action. And you go and you spend, say $5,000 to get your judgment. And you're like, well, I want that $5,000 back from the seller. Oh, well, guess what? It wasn't a contested action because the seller didn't answer. And your contract doesn't allow for an award of attorney's fees, so now you're out that. Yeah, it's a bummer. So
they got, in that scenario, at least they got their judgment for 5 instead of not 12 or 15.
Right. Exactly. So, it's important to have that in there because you don't want to, lose at the same time that you win
For
as
sure.
well. So.
Yeah. And I'll remind everyone, the victory isn't in getting a judgment, it's the collection,
Oh,
That's
yeah.
where the glory is. Big whoop, you got a judgment, but like good luck collecting on it. Judgments, unless they own real property that you can lien it with, it's like it's not really that great yet. I mean, it's going to take you a while to get anything out of it. So.
Paul, one area, a big area that you spend a good bit of time with is securities laws. And if folks are just watching and you're seeing Paul for the first time, go back and we did an entire episode on securities law, and it's enough
It was pretty good too. I'd say it was pretty good.
Yeah, well, yeah, all because of you, and it's enough to keep you awake at night.
Yeah,
If
well,
you're
no
an
promises there. No promises.
Yeah,
there.
if you're an investor and you don't have an appreciation for the securities laws and things, you really need to. So from your perspective as a securities lawyer, what are the biggest mistakes that you see with regard to security screw-ups because the contract wasn't done properly?
Yeah, so you're like we talked a little bit about it earlier, protecting your value, making sure you're going to sign that contract, because you need an ultimate property owner that's probably going to be split up amongst partners for when you sell equity to these investors. So make sure you have that in there. The other problem I see, and this is more after it's under the PSA, like everybody signed, is qualifying what a security is. A lot of people are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean? Oh, I only got like 4 or 5 people, but we're all going to JV it. Like, that's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932, right? Like, they've thought of all these things. So if someone's in your deal passively, it's a security. And then at that point, you need to make the business decision. Is this a deal that I want to do properly? Get a lawyer involved. They'll do these stupid disclosures and PPMs and all this other stuff. Or do I want to roll the dice and save a few bucks? Now, that's really all it comes down to, right? It's like the deal has to be good. If the deal's not good enough to pay a lawyer to do it, don't do the deal. It's not that good of a deal. If you can't spend, there's a lot of reasonable securities lawyers out there that's right around $10,000, and you can get the pay structure can be different and stuff. But you got to get it done properly, because if you have a passive investor, you got to get the securities work done, because the risk of it's like having insurance, right, in a property. Well, if the place never catches fire, like, what a waste of money. Like, why do we even have this thing? Well, your lender needs you to have it, and at some point, if it's a decent property, there will be a fire. The same goes for the securities. Now, if you don't have the securities work done and that investor of yours wants their money out, and they're like, hey, I've had this deal in here for 3 years. I don't really hear a lot from you. I want to buy sub 2 properties and use this capital, so give it back. Like, if you don't have an agreement with them, or lots of reiterations of this money's going to be busy for 5 years, you can't get it back. What are you going to point to and say, actually, I need your money for 2 more years? And then they can just raise all hell and get, any boob lawyer involved, and that person can cause you a lot of problems. So defining what a security is, understanding that it's very basic. That's the simplest way, is if someone's giving you money and not going to do anything and hopefully get a return on that money, that's a security. If that's the case, call up a securities lawyer, because not every deal needs the PPM, but there's going to be some calculations involved and decisions to be made, and you can do it properly. So
I'm curious to know whether there are a lot of mistakes that happen in the security side of things, where maybe they did all of the work well contractually on the front end, but they just mismanaged, whether it was communications or their dealings with investors. And one of the things I recall is we had on as a guest a hard money lender. His name's Andrew Bang. And one of the things that they said was always a red flag from a hard money lending perspective is oftentimes you would get the folks with the money in the deal, a lot of the times were the passive ones, because they had done well, right? Maybe they were retired and they didn't really want to do the legwork. They just wanted to put their money in and get a return. And the one without any money was the one kind of running the ship. But they had the least.
I would say 95% of the time that's the case. Probably.
How is it best to, is that just the nature of things, or
Yeah.
are there ways to mitigate that?
Yeah, I mean that's just the nature of syndication, right? It's like you're buying something that you can't otherwise afford yourself. Then you got to come up with this like plan of what you're selling to an investor, and hopefully that's good enough that an investor will give you the money in exchange for the security, right? They're going to buy part of that title owner. It happens in the great majority of our deals where the person putting the deal together is going to be the sweat equity side, raising the money, getting the deal closed, figuring out the sponsorship and closing the loan. And then the investors are just going to sit back and hopefully get their targeted returns that were described in the offering memo and stuff. So yeah, that's not unusual. The problem becomes lack of communication, right? So if you bought property in 2020 and then all of a sudden now there's no tenants that are having to pay because they don't have to get evicted, right? They have 12, 18 months or whatever to save their money or to just not pay. You need to communicate to investors. So that's a big thing, right? It's like, well, if you're an investor and you haven't heard from anybody and you certainly haven't gotten your quarterly distribution, you're now believing the internet that everybody that does that is now in Cabo, drinking and not working on the property. So communication's key. And then also making sure you're not guaranteeing anything, right? It's like if your investors need to know that there's no guarantee, you never say guarantee. If they're like, well, isn't this money guaranteed? No, it's not. Our target is to hit you 10% every year. But we might have these contingencies. And these are what we talk about in the PPM. There could be a global pandemic. And when that happens, we're not going to get a tenant to pay us. We have labor that we have to rely on. And it's really hard to find contractors. So if that's the case, we might not get the units turned like we want. It might take us 18 months instead of 30 days like we were hoping. So yeah, that communication's key. And then not overpromising, I think, is the other really important factor.
Just curious, how much disclosure did you do in your PPMs prior to 2020 regarding pandemics and epidemics?
Zilch. Zilch. I mean, we had some disclosures in there about natural disasters, so you could say sort of, right?
Exactly.
But was there litigation based on that? I'm sure. I don't know what it was, but if I'm an investor, that's a creative thing. Like, hey, you never told me, that we could get some disease traveled overseas and shut down the whole country for 18 months, But importantly, communication is huge, right? So if you talk to your investors, lawsuits aren't often filed just on a whim,
Right.
So if you're silent on the issue and you're getting calls and texts and people are pissed, take that head on. Otherwise, you have to hear from a damn lawyer, which is no fun.
Right. Maya, do we have a question? Go for it.
All right, so we only have one question today. This one is a little specific, so I'm going to paint the picture for you, just anyone in particular, so feel free to answer. What can be done if you closed on a wrap and the primary principal has been locked up? In this example, they're on a hold from ICE. So moving forward, how can I protect myself for future contracts? Can I put power of attorney in place?
So you've closed on a wrap transaction and the owner is now subject to some type of ICE hold. Is that accurate, Mayu?
The old customs enforcement, huh? That's what I'm reading here. I presume that's what they mean.
Well, I mean, look, if the subject to transaction was done the right way, that should not be an issue. So there's some safeguards that are put in place at the beginning with the right paperwork. So for example, the owner, you want the seller to provide a power of attorney with respect to mortgage insurance and future escrows, where you can basically execute certain documents on their behalf in order to, sell the property subsequent to your taking title. So you're the title holder. You want to be able to give instructions to the mortgage company regarding insurance. You want to be able to give instructions regarding insurance. And then you also have authorizations to release information, assignment of insurance proceeds. In addition, you have, and we had Alan Seschker on our show maybe about a month ago now. And he, in my view, is one of the top rap attorneys in the nation. He said that he builds into his deed of trust a provision that says, hey, if the underlying loan is paid off and released, that acts as a release of this deed of trust. And no further recording is required, no further deed of release. So you don't need to go track down, the seller who's in, ICE custody. On top of that is if you use a servicing agent, then at the beginning, the seller would have executed a deed of release and reconveyance and placed it in escrow with the servicing agent. So once that loan is paid off, the servicing agent can record or provide the original deed of release and reconveyance, which takes care of that problem. So it sounds like the issue is more of a structuring problem from the beginning than actual, performance later on. If you structure it properly, that seller can go travel the world and you don't even need to contact them. You don't need to be able to reach them because you're fully 100% in control of that property and can deal with that property, can convey that property, can lease that property, can do an agreement for sale for that property. You can do whatever you want. You can pay off the loan and have a release recorded if it's structured and done correctly. You shouldn't care if they're in ICE custody. If they're now in ICE custody, well, that's a whole different story. And you may have to, where you've not done it right, you may have to figure out, what you can do through the courts as far as getting, orders in place that allow you to do certain things with respect to the property. But once again, it gets back to contracts, right, Paul? Like, how do you structure it so that you don't have these issues in the future?
No, that was a great answer. I think the only thing to be concerned about is, do you guys have in Arizona, what is that called, where they, basically a party sues a seller for a bad conveyance, like they're trying to avoid a creditor, right? I can't remember what the title
fraudulent,
of
that. Fraudulent
transfer.
transfer.
That's the big fancy word. See, I don't have those $5 words in my pocket. So that's the only concern with is if something was transferred for that reason, right? They knew somebody was going to come and get them for taxes owed or for a debt or something like that. That'd be the one chance that, like, sometimes you just get screwed as a buyer unknowingly. Exactly. And then you'd have to go and, you'd have to go after the seller yourself, which you wouldn't want to do. But yeah, that was a great answer. I don't, if you have everything in place, I shouldn't be a problem. But of course, they're the government, so could be. So.
Well, Paul, thank you so much for taking the time and joining us. We appreciate it. How can our listeners find and connect with you?
Yeah, so on Facebook, Instagram, pv.esq is the handle for both of those. You can email me at paul@vincentesq.com if you have any questions or want to connect up. But yeah, thanks so much for having me on. Appreciate this every time. It's fun. Usually talking to lawyers isn't that fun, but this is pretty fun. So appreciate you guys having me.
Yeah, we'll look forward to having you again. Bring your brother next time. We'll make it.
Yeah, I will. Yeah, that'll really mix it up. So that'd be great.
All right, Paul. Thanks so much. We'll see you next time.
See you guys.
Paul.
All right, with that, everybody, that is our show. Thanks for joining us. Make sure to be with us every Tuesday morning at 10 a.m. Arizona time. You can also get our on-demand episodes on YouTube at InRem Podcast. Make sure to subscribe. We'll see you next week.
Have a good day, everyone.